Hi class, this week we're going to work on chapters 30, 31, and 32. Chapter 30 is about bankruptcy. The Constitution gives Congress the power to legislate on bankruptcy. The current law is the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, which provides for 6 types of proceedings: liquidation, or Chapter 7, adjustment of debts of a municipality, or Chapter 9, reorganization, Chapter 11, family farmers with regular income, Chapter 12, individuals with regular income, Chapter 13, and cross-border bankruptcies, which is Chapter 15. With some exceptions, any individual, partnership, or corporation seeking liquidation may file a voluntary petition in bankruptcy. An involuntary petition is also available. Creditors petitioning for that must meet certain criteria. A petition operates as a stay against the debtor for lawsuits to recover claims or enforce judgments or liens. A judge will issue an order of relief and appoint a trustee who takes over the debtor's property and preserves security interests. To recover monies owed, creditors must file proof of claims. The trustee has certain powers to recover property for the estate that the debtor transferred before bankruptcy. These include the power to act as a hypothetical lien creditor to avoid fraudulent transfers and voidable preferences. Under Chapter 7's 2005 amendments, debtors must pass a means test to be eligible for relief. If they take too much money, they must file Chapter 13. Certain property is exempt from the estate of an individual debtor. States must opt out of the federal list of exemptions and substitute their own. Most have. Once discharged, the debtor is no longer legally liable for most debts. However, some debts are not dischargeable, and bad faith by the debtor may preclude discharge. Under some circumstances, the debtor may reaffirm a discharged debt. A Chapter 7 case may be converted to Chapter 11 or Chapter 13 voluntarily, or to Chapter 11 involuntarily. Chapter 11 provides for reorganization. Any person eligible for discharge in Chapter 7 is eligible for Chapter 11, except stockbrokers and commodity brokers. Under Chapter 11, the debtor retains possession of the business and may continue to operate it with its own management unless the court appoints a trustee. The court may do so either for cause or if it's in the best interest of the creditors. The court must appoint a committee of unsecured creditors who remain active throughout the proceeding. The debtor may file its own reorganization plan and has the exclusive right to do so within 120 days if it remains in possession. Chapter 13 is for any individual with regular income who has difficulty paying debts. It's voluntary only, and the debtor must get credit counseling. The debtor presents a payment plan to the creditors, and the court appoints a trustee. The plan extends the time to pay and may reduce the size of the debt. If the creditors wind up with more in this proceeding than they would have in Chapter 7, the court is likely to approve the plan. The court may approve a stretch out of 5 years. Some debts not dischargeable under Chapter 7 may be under Chapter 13. Chapter 31 is Introduction to Property, Personal Property, and Fixtures. Property is the legal relationship between persons with respect to things. The law spells out what can be owned and to the degree to which one person can assert an interest in someone else's things. Property is classified in several ways: personal versus real, tangible versus intangible, private versus public. The first distinction between real and personal is the most important, for different legal principles often apply to each. Personal property is movable, whereas real property is immovable. Among the ways personal property can be acquired are by possession, finding, gift, accession, and confusion. Possession means the power to exclude others from using an object. Possession confers ownership only when there is no owner at the time the current owner takes possession. So if you think of when you were a kid and you said finders, keepers, losers, weepers, it's not a universal rule. The previous owner is entitled to return of his goods if it is reasonably possible for him to locate them. If not, or if the owner does not claim his property, then it goes to the owner of the real estate on which it was found. If the finder was a trespasser, or the goods were buried, were in a private place, or were misplaced rather than lost. If none of these conditions applies, the property goes to the finder. A gift is a voluntary transfer of property without consideration. To make an effective gift, the donor must make out a deed or physically deliver that object to the person it's going to. Or the donor must intend to make a gift, and the last one is the person receiving the gift must accept it. Delivery does not always require physical transfer. Sometimes surrender of control is sufficient. The donor must intend to give the gift now, not later. Accession is in addition to that which is already owned. So, for example, the birth of a calf to a cow owned by a farmer. But when someone else, through labor or by supplying material, adds value, the accession goes to the owner of the principal goods. Confusion is the intermingling of like goods so that each, while maintaining its form, becomes a part of a larger whole, like grain mix in a silo. As long as the goods are identical, they can easily enough be divided among the owners. A fixture is a type of property that ceases to be personal property when it becomes real property, when it's affixed or annexed to land or buildings on the land and adapted to the use and enjoyment of the real property. The common law rules governing fixtures do not employ clear-cut tests, and sellers and buyers can avoid many disputes by specifying in their contracts what goes with the land. Tenants' fixtures remain the property of the tenant if they are for the convenience of the tenant. They don't cause substantial damage to the property when removed and are removed before the possession is returned to the landlord. Chapter 32 is about intellectual property. The products of the human mind are at the root of all business, but they are legally protectable only to a certain degree. Inventions that are truly novel may qualify for a 20-year patent. The inventor may then prohibit anyone from using the art, the machine, the process, manufacture, and its like, or license it on his own terms. A business may sue a person who improperly gives away its legitimate trade secrets, but it may not prevent others from using the unpatented trade secret once publicly disclosed. Writers or painters, sculptors, composers, and other creative artists may generally protect the expressions of their ideas for the duration of their lives plus 70 years, as long as the ideas are fixed with some tangible medium. That means that they may prevent others from copying their words or paintings, etc., but they may not prevent anyone from talking about or using their ideas. Finally, one who markets a product or service may protect its trademark or service or other mark that is distinctive and has taken on a secondary meaning, but may lose it if the mark becomes a generic term for goods or services.